Have you ever received a call from a lawyer or a debt collector demanding a payment on a debt that you forgot about years ago? If you have not, it is possible that you could receive such a call in the future. If you do receive or have received such a call, how would you or how did you react to the caller? And that is a very, very important question. Before going further, let me state that I am not advocating that you or anyone else should not pay your debt. Of course you must, but sometimes it happens that a person fails to or is unable to. Maybe he was retrenched or had no income. Having no income means that you stop paying your debts. You probably forget about it because you have not heard from your creditors, and then one day out of the blue you are contacted. If this happens, you might have certain rights, and so do your creditors. The purpose of this video is to highlight your rights, what you may do, and what your creditors may and may not do. I am Michael Lilly, and I'm going to try and simplify and explain prescription of debt, or prescribed debt as it is sometimes referred to. A person may acquire rights or be discharged from obligations over a period of time. This is known as prescription. Simply put, prescription is the law that determines the life of a debt. How long can one legally collect on such a debt, and the rules that relate to collecting old debts. The Constitutional Court described the reason for prescription as follows, and I quote, "Claims lapse or prescribe after a certain period of time. If a claim is not instituted within a fixed time, a litigant may be barred from having a dispute decided by a court." And this has been recognized in our legal system for centuries. End of quote. What are the consequences of prescription? Well, first of all, a person who is indebted, the debtor, to another, the creditor, will not be liable to pay such a debt after a certain period has passed. This means that the creditor may not institute legal action against the debtor for the debt. The aim of prescription is therefore to achieve legal certainty and to finalize the connection between a debtor and a creditor, and in so doing protect the debtor, who is the consumer, against the unfairness and illegality of having to defend old claims. As a result, old debts are terminated or cancelled, or they lapse after a certain period of time by what is known as prescription. This prescription of debt is regulated by two important acts. And the first is the Prescription Act 68 of 1969 and the National Credit Act of 2005. The Prescription Act mainly regulates all aspects of prescription, which includes consumer debts. How do I know if a debt might have prescribed? Section 11 of the Prescription Act determines the time period after which a debt will prescribe. Certain debts such as a mortgage bond, a judgment debt, or any debt related to tax or debt owed to the state, the term is then 30 years. Then we have other debts which vary from 6 to 15 years before they can prescribe. But we are concerned with the normal consumer debts such as loans, credit cards, store accounts, etc. In these instances, the period is 3 years. Here I have a timeline, and our period, let's assume that our period starts running in October 2016. 3 years later will be October 2019. Now, Section 13 to 15 of the Prescription Act states which actions may interrupt or delay the period of prescription and cause a new period to start running afresh. Right, now we're going to be concerned about the interruption of prescription. And when we're talking about interruption of prescription, it means when can that period stop or be ended. Let us assume that during this period you never paid anything towards the debt, you were never contacted, and you never acknowledged the debt. You never received a summons or a judgment. Then according to the Prescription Act, the debt would have prescribed. So the usual period for most debts with which we are concerned is 3 years. Therefore, a person who is indebted to another under the National Credit Act will not be liable to pay such debt after the 3-year period is passed, provided that nothing took place during this period. This also means that the creditor may not institute legal action for this debt. However, this can be interrupted by the creditor by taking legal action and obtaining judgment before the 3-year period has passed, which would then extend the life of a debt to 30 years as a result of a judgment. Right, what I'm saying is this: if a creditor institutes or issues a summons and it leads to a judgment, your new prescription period then will be 30 years. Or, if you pay the debt up before then obviously the 30 years will not be valid anymore. Section 14 of the Prescription Act states the running of prescription will be stopped by an express or tacit acknowledgement of the debt by a debtor. Excuse me. Right, what do they mean by express or tacit acknowledgement? It means, sorry. If you admit that you owe the debt during this period, or if you sign an acknowledgement of debt during this period, or if you make a payment to the debt during this period, then this prescription period is cancelled. It's interrupted. And let's say, for instance, you make the payment here in June 2017 and nothing thereafter. It means your debt will expire or prescribe in June 2020. That's another 3-year period, provided there's no summons and judgment, provided you do not admit you owe the debt or sign an acknowledgement of debt or make any payment again in that period. So that can interrupt prescription, and your prescription starts running from that date again, provided nothing else interrupts prescription. Right, these are just some of the possibilities where the running of prescription can be interrupted and will start running afresh. Section 15 of the Prescription Act states that the running of prescription shall be interrupted by the service on the debtor of any process whereby the creditor claims payment of the debt. What that means is the running of prescription is interrupted by a summons served by the creditor on the debtor, the consumer, in order to claim payment of the debt. Let us just summarize what we've heard. In general, if a debtor in a specific time frame makes no payment towards settling a debt, he or she does not acknowledge owing the debt or agrees to pay it, or if the creditor does not demand payment from a debtor, or start legal action against him or her, or communicate with him or her in any manner, and within that required time period, a debt becomes prescribed. Nothing happens, it prescribes. Summons interrupts it, or if you admit it, or sign an AOD, or make a payment, it will interrupt prescription. Now here comes the best part. If you are a consumer who believes that your debt might have prescribed, in order to protect consumers, the National Credit Amendment Act introduced Section 126B. And this means that if you are contacted regarding a debt that you believe has prescribed, you may raise the defense of prescription, even if that debt has been sold. How do you do that? Well, when a person calls you, all you do is you tell them that you raise the defense of prescription. That's all you tell them. Nothing else. Never admit or acknowledge the debt. Never sign anything. You can also tell them that you don't know what they're referring to and that they must send you a statement from inception, from the beginning, to today, showing all payments made on the supposed account so that you can substantiate their claim. Remember, you do not know the person calling you. They can tell you anything. There's so much fraud today that you can't prove anything, so let them prove it. The best option is to merely state that you raised the defense of prescription. That's it. And once you do that, the onus is on the caller, the creditor, or the debt collector to prove otherwise. That is what the law allows you to do. But remember, if you acknowledge the debt, admit to the debt, you will have to pay the debt. So make sure that you answer or respond correctly. And if you forget what to say or do, here's a tip. All you do is deny, deny, deny. That's it. Don't acknowledge it. If the debt has prescribed and you respond correctly, you will probably not hear from them again. If they've got a valid claim, they will contact you and prove it. That is it for this video. If you are over indebted, why not call us and see how we can help you in your situation. We assist consumers who are struggling to pay their accounts each month, but who do not wish to go under debt review. You have nothing to lose but your debt. Thank you so much for watching, and I hope that you will benefit from this video. Please share it with at least one friend. Who knows, you may be helping him or her. Thank you.